interest of democracy and good etiquette that he should be present. Now, I think I've taken up 2 minutes of not saying much, but unfortunately he's still not here. So allow me to go on, even though I'll go on at a slower pace. I think, well, I just hope that someone could at least tell him to show up. Now, when I look at this piece of legislation and what it brings to my mind, Mr. Deputy Speaker says the following. It brings to my mind a government that when you look at all the issues it is trying to bring in through this bill, it is a government that clearly is seen to be trying to get hold, to take control of various situations, to take total control of various institutions, of various decision-making instances and bodies, in order that it may have control at very important times for important issues. And it is only a government that does not have control anymore that acts in such a desperate manner. Because yes, what I see in this piece of legislation is there is a common denominator there. And the common denominator is desperation. A government that is no longer in control because it knows for a fact that it is not only whatever it wishes that, for instance, the Law Reform Commission must do. It is not only what it wishes that the Law Reform Commission members must bow to. It is not always government's agenda that must be the order of the day. But the government cannot accept that. The government, through this bill, I see, is a government that cannot accept independence. It is clearly showing, Mr. Deputy Speaker, sir, that it is allergic to the independence of institutions. It fears the independence of thought of members of institutions. It fears the independence that the Mauritius Bar Association has as an institution. So what it does, it tries to take control, but not through means that I would qualify as being ethical. Because ethical would mean, and I'll start by giving an example, if we're to talk about the Mauritius Bar Association piece of legislation that is being amended through the clause here in clause 9 of the bill. It is important that all those listening here in this chamber and outside at least ask themselves, why is it that the Attorney General is coming up with this piece of legislation? What, in fact, he is trying to achieve. Because all the excuses that he has put forward, and yes, I call them excuses, are but lame excuses. Extremely lame excuses. The truth of the story is that because there was an incident involving a law officer from the office of the Solicitor General, because there was an incident where the Mauritius Bar Association called that officer to give explanations concerning an incident, the manner in which the Bar Association was seen to have dealt with this matter was not to the liking of the Attorney General, and I'm sure was not to the liking of the officers of the Solicitor General's office and the DPP's office. And because of that, today we are having a piece of legislation where, what are we doing? We are creating a situation where we are going to end up with two categories of lawyers. Two categories of barristers. One that will be totally governed by the Mauritius Bar Association. One where in matters of discipline as members of the bar, the Mauritius Bar Association will be able to act, and another category of lawyers where it is owned, not the Mauritius Bar Association will not be allowed to act. Now, when I see this piece of legislation, the Mauritius Bar Association Act is being amended, and the words that are deleted are the words Attorney General in Section 5(1) of the Act. And what finally it would read, if we are to remove it, is that the Attorney General will not de facto form part of the Mauritius Bar Association. The Bar Council will not consist anymore of the Attorney General de facto. And the 5 members are increased to 7. But most importantly, it is clause, it's the other clause in clause 9b, which is in section 13 of the Act, which is being amended. And it says here, for the avoidance of doubt, this section pursuant to section 86 of the Constitution shall not apply to a law officer under the Law Officers Act. What exactly does that mean finally? It means that if it concerns law officers who are appointed by the Judicial and Legal Services Commission, barristers called to the bar, there is a code of ethics that all barristers have to adhere to, a code of ethics for the good running of our profession. Barristers have to adhere to that. But what the Attorney General is doing through this piece of legislation is creating, as I've said, two categories of barristers. One that will be governed by the Code of Ethics, and if ever there's a violation of that Code of Ethics, the Mauritius Bar Association will be able to take action and then eventually refer it to the Supreme Court if ever it has to be referred to the Supreme Court for any decision of the Supreme Court based on a violation of ethics. Then the other category is they remain, the law officers appointed by the Judicial and Legal Service Commission will remain members of the Bar Council, the Bar Association, they'll remain. But the section of the law in relation to discipline, for violation of ethics, for misconduct, that will not be applicable to the law officers. Therefore, it will be, according to them, the Judicial and Legal Service Commission that will be able to take action against them, if ever there's been misconduct. So therefore, we end up with two categories of barristers. One, where the Judicial and Legal Service Commission is called upon to take disciplinary action against them, if need be. And if you are not a law officer appointed by the Judicial and Legal Service Commission, but you are a barrister qualified and called to the bar, you then are not a law officer under section 86 of the Constitution, then it will be the Mauritius Bar Association that comes into play. Two categories. So what I've done is tried to understand, maybe in other jurisdictions, do we have an instance that exists that deals, one, with officers working for the Crown Prosecution Service, officers working for the state, let us say in the United Kingdom, barristers working in the United Kingdom? Are they dealt with differently in matters of discipline as opposed to barristers who are in private practice? So I have researched it and come across one very simple scenario as it happens in the United Kingdom. And the scenario is, you've got the Bar Standards Board. The Bar Standards Board is the board whereby once you have passed your exams, the bar exams, once you have qualified as a barrister, once you have been called to the bar in one of the 4 Inns of Court, you have, as a barrister, wanting to practice as a barrister in the United Kingdom and Wales, have to go to the Bar Standards Board in order to obtain a certificate that allows you to practice as a barrister. And if there is any misconduct on the part of a barrister, if there's a violation of the Code of Ethics, once again, it is that one single body that is called into play. It is the Bar Standards Board. In the United Kingdom, one does not have 2 instances to deal with barristers working for the state, as far as ethics goes, and then barristers working for the private sector, not working for the state, in a different manner. You have only one instance. Why? Because barristers are called to the bar, barristers whom I have a lot of friends, and if not all of them are good friends and colleagues of mine working for the Solicitor General's office, the DPP's office, and even the AG's office. We are all barristers, we are all brothers and sisters of one profession. And all of us are governed by one simple rule. Our code of ethics is the discipline that we have to adhere to. And if there's a violation of any code of ethics, we have to be disciplined in the same manner and with the same standard. Because a barrister is a barrister. There are no 2 categories. There is only one category. And we have only one appellation. We are barristers. That is a simple equation. There is no need to complicate it. In the United Kingdom, it is not complicated. In France, it is not complicated. In other Commonwealth jurisdictions, it is not complicated. In other Commonwealth jurisdictions, there is only one body that disciplines barristers, and not 2. I have searched and perused other documents to try to find out whether in India there are 2 bodies. The answer is no. So therefore, why Mauritius? Why here? Why this knee-jerk reaction of the Honorable Attorney General simply because he refuses to simply put aside the fact that they may have felt, and je compatis, that the Bar Association wrongly reacted pertaining to one officer whom I have a lot of respect and friendship for. Let us try a comparison to us to understand it. And if I am to choose another profession, I see Honorable Hasnu present, I'm happy. Let us think about doctors working for the public sector, as opposed to doctors working in the private sector. Imagine there is misconduct on the part, or negligence on the part of a doctor in the public sector. Isn't it a matter which the minister can refer to the medical council? Yes, it is. But if you're in the private sector, isn't it, once again, if there is wrongdoing, a matter that has to be investigated and then referred to the medical council? Or is there another council altogether that will look into matters concerning medical doctors working for the private sector as opposed to the public sector? Why is that? Why is it that we do not end up with 2 institutions for doctors? We should not confuse the fact that the Public Service Commission employs, the Judicial and Legal Service Commission recruits and employs. And then they will say, but no, Honorable Mohamed is wrong. And some would say I'm making my show. But then again, no, the show hasn't started yet. It's about to. It's about to. Of course I accept. Whatever you say is true.
No cross-talking, please.
Yes. Whatever you say is true, always. You always truth. That's called sarcasm. By the way, and what I find interesting is here, and I think those are very important sections that we have to bear in mind with regard to this piece of legislation and try to be very dispassionate about it. And this is what exactly I'm trying to do. It's not a show, but being dispassionate about it. I have my views. I am respectful about the views of others, but I may not agree with it, but I have to communicate my views. This is the whole purpose of our presence here today. Here, when they say they are going to refer to the appointment of judicial and legal officers, the Honorable Attorney General obviously is referring to, when he says in this bill that this section shall not, pursuant to Section 86 of the Constitution, not apply to a law officer under the Law Officers Act. Qu'est-ce que cela veut dire? When I refer now to Section 86 of the Constitution, I read 86(1) of the Constitution. The Judicial and Legal Service Commission, which is created under Section 85 of the Constitution, shall have the power to appoint persons to hold and act in offices to which this section applies, including the power to confirm appointments, to exercise disciplinary control over persons holding or acting in such offices, or to remove such persons from office, shall vest in the Judicial and Legal Service Commission. This is what the Honorable Attorney General is relying upon. Because here, there is part of that paragraph that says that the Judicial and Legal Service Commission appoints those very law officers. And that is this very Judicial and Legal Service Commission that has the power to appoint them, that also has the power to exercise disciplinary control over those persons. So the Honorable Attorney General bases himself upon this particular section of the Constitution where the word disciplinary control is referred to say that is why we can derogate from the Mauritius Bar Association legislation. We will be disciplined in matters of violation of the Code of Ethics by the Judicial and Legal Service Commission. This is what is their legal reasoning. And I humbly put it that their legal reasoning is unfortunately flawed. And I shall explain why it is so flawed and dangerous. Because in actual fact, it is important that we go to the Judicial and Legal Services rules. It's very important that we read the Judicial and Legal Services Commission regulations, because it does not stand only in the Constitution as Section 85 and 86, but the Judicial and Legal Services Commission, they have regulations. And those regulations are the Government Notice 90 of 1967. And when one reads the relevant sections of the regulations to see what exactly can the Judicial and Legal Service Commission do in terms of discipline, and I think it is of relevant reading here, and I shall read that. Regulation of the Judicial and Legal Service Commission, Section 17, Paragraph 1. The penalties which may be imposed on an officer against whom a disciplinary charge has been established are: 1. Dismissal. 2. Reduction in rank. 3. Stoppage of deferment of increments. D. A reprimand. E. An officer who is absent in Mauritius without permission shall be liable to summary dismissal. And in the event that in the public interest it is found that he has to be made to resign, he is asked to resign and the Attorney General steps in. Those are the very clear parameters, Mr. Deputy Speaker, sir, of how the Judicial and Legal Service Commission operates in matters of disciplinary proceedings. Therefore, the question that I ask is, and we should all ask ourselves, does the Judicial and Legal Service Commission have the power pertaining to Section 86, as well as the regulations, the power to discipline any officer appointed under Section 86 for violation of a Code of Ethics? Do any of the regulations that I've referred to refer in any way to the Code of Ethics? And why I say the answer is simply no is because I refer to the case of Pandey. the Pandey versus Judicial and Legal Service Commission, which is a Privy Council matter. When you look at that judgment of the Privy Council, in the case of Pandey, the law lords of the Privy Council referred to Section 86 of the Judicial and Legal Service Commission creation under Section 86 of the Constitution. They also referred to the regulations of the Judicial and Legal Service Commission, GN 90 of 1967, and the ambit of the disciplinary powers of the Judicial and Legal Service Commission is limited to matters of employment. Full stop. In other words, it is an employer. And the law framers have explained very clearly, those are the ways that those employed who are now law officers, recruited by the Judicial and Legal Service Commission, those are the officers who will now be disciplined in the following manner. And part of the disciplinary process would be to dismiss them from the employment if ever the disciplinary charge is approved. It would be to reduce their rank in the hierarchy of the place of work in terms of their employment. Stoppage of deferment of increments with regards to their job. A reprimand, just like a warning we call it. And those listening on television would understand what I mean, since they get in day out. A warning under industrial laws. But at no time does the Judicial and Legal Service Commission have the power to look into anything that goes in relation to the Code of Ethics. The Code of Ethics, the only statute that has been created with regards to the respect of the Code of Ethics of barristers, is the Mauritius Bar Association. And at no time was it in the mind of the framers of our Constitution that this Judicial and Legal Service Commission should also have the power to come and take any disciplinary matter for violation of Code of Ethics. Neither do they have any statutory power to even refer a violation of Code of Ethics to the Supreme Court. It is only the Mauritius Bar Association, the council, that can refer a matter after investigation to the Supreme Court, and this is provided for by statute. Now, if the Attorney General is to tell me that Section 86 that is trying to bring in order to create a second category of barristers, two categories, does also provide for disciplinary action for violation of the Code of Ethics and to be referred to the Supreme Court, here, he can at least show it to me, because I've looked for it, it's not there. He can try to read into it. That is not allowed to do. He can try to interpret it, turn it, twist it to make it go his way. But the truth is the truth. Statutory interpretation is clear. You cannot here ask the Judicial and Legal Service Commission to do something which it has no right to do, because it was never empowered to do so. In other words, the legislation that he is passing is giving powers to the Judicial and Legal Service Commission that the Commission cannot even do, because to do so, he would have to amend Section 86 of the Constitution, and he would have to go as far as to amend the rules, the regulations, because the regulations will have to also include that. And it doesn't. But what is more worrying, and I'd here like to ask the Attorney General to answer that. He is de facto a member of the Mauritius Bar Association. He is de facto, practice dictates, the vice chairman of the Mauritius Bar Association. I have taken it upon myself to consult with the Mauritius Bar Association in order to find out exactly what was their stand pertaining to this particular amendment. At a time where the Mauritius Bar Association is taking difficult decisions, but what shows very courageous decisions, in order to try to show that it wants to bring discipline at the forefront of its mission. It wants to bring in unity dans le corps of barristers. It wants to put in the forefront of its mandate the concept of discipline, when at a time when it's trying to call for and been calling for through meetings it has had with the Honorable Attorney General. They have asked him for big amendments, not only pertaining to piecemeal amendments as the Attorney General is bringing today, which goes not in the interest of the profession, not in the interest of justice, but in the interest that is very egoist, in my humble view. Très egoist, but not thinking of the greater good, but only thinking small. Small thinking, little. And that is the sad part, because at no time did him, as member of the council, did he even consult with them pertaining to this amendment. And this is what I've been told. The Mauritius Bar Association, the Mauritius Bar Council, at no time was consulted by the Honorable Attorney General. Isn't it good practice? You've heard the Honorable Attorney General in his opening remarks state that how he would do everything according to law, how he would do everything according to good governance, how he would do everything according to good practice. But doesn't good practice and etiquette simply ask that he consults with the members of the association? An association that is governed by the Mauritius law, the statute that is trying to amend, the Mauritius Bar Association. He's trying to amend that statute that governs the barrister's profession, but he does not consult with the same association members, neither does he consult with the council members, neither does he consult with the barristers of the profession, and he does it behind their back, whilst at the same time being a member of the association himself. Maybe he's got a different concept of the word consultation. But in all humility, and with a mind that wants to be constructive and not destructive, the least I expected from him is to consult with the members of the bar at the time when to decide that he's going to amend a statute that creates the Bar Association. But no, he decides to create two categories of barristers, removes the power of the Mauritius Bar Association as far as disciplinary matters concerned for barristers working for the public, appointed under Section 86, and does not even consult with the Mauritius Bar Association. Is this good governance? Mr. Deputy Speaker, sir, I fail to understand what exactly he is trying to get at. And I go again, and I'd like the Honorable Attorney General to be able to bring an answer to this. How can he expect the Judicial and Legal Service Commission to operate in a vacuum? And why is there such a vacuum? Is because the Judicial and Legal Service Commission is not empowered to take any disciplinary action in relation to violation of Code of Ethics. It is empowered, however, to take disciplinary action in relation to misconduct and only go as far as to sanction the employment of the law officer, but not the appartenance to a profession. Can the Judicial and Legal Service Commission go as far as to report to the Supreme Court? Can they go as far as to summon him, and if he faces to summon on the Code of Ethics? Nowhere in the regulations is the Code of Ethics mentioned. Nowhere in the regulations is reference to the Supreme Court for violation of Code of Ethics referred to. So there is a missing link. I always laugh and smile happily because it reminds me of the good old days when Honorable Senator Ambu talked to me the first time I met him about what a missing link means. And those were the good days when I was still a student and he was a student in London. If he doesn't remember, I'll tell it to him later on. And it was a nice joke he shared with us. But the missing link is important. The missing link is important because you cannot ask the Judicial and Legal Service Commission to do something it is not empowered to do. Now, before I go on to the next issue, I shared this with my friends earlier on while we were having dinner. And I said to them that there is something that is very frustrating, Mr. Deputy Speaker, sir, and it is the following. I stand before you today sharing my views, the legal analysis that I have put in here. And I think it makes interesting debate. And that's the whole purpose of us being in this August Assembly. A debate on ideas, reasoning. And for us to come here, we must have a reason. But when we have on the other side a government that just listens to you pour la forme, or at least pretends to listen pour la forme, but never takes into account anything you say, because at the end of the day they've already made up their mind, and we have to give a semblance of democracy, go through the act of making some contribution today, and that's never taken into account, that it's thrown aside as though it's irrelevant, and then you understand that it leads to frustration. And then sometimes at the beginning of my speech, a few minutes before that, I said to myself, most probably it was not worth intervening, but at least my friends convinced me that it was important to do so for posterity. Why is it important for posterity? Because it is important for the future generations to see this is the wrong they were doing. Because not far from today, when my honorable friend from Honorable Boulel stated that the writing is on the wall, he's right. And the Labour Party will not stand by and see any law abusive in nature stay on the books, and we undertake to repeal those laws that are wrong. We will do that when we come to power. That is an undertaking we take. We make it and we solemnly take it. That's what you think. When you were with the Labour Party, then your tongue was going the other way. But then again, I mean, the tongue issue, you know, I mean, it's an expert, they have expertise with that. Honorable Sinatambu, when he was with the Labour Party, my God, how he was so critical of the Jugnuts. And now when he's with the Jugnuts, he's so critical of Ramgulam. My God, he is so good. Huh? Huh? Yes, he's a missing link. Missing link. Oh, so what he's saying is because I did the same thing, it makes him right. That's a very good defense. You understand why he's turning yellow now? Yes. Now, you understand why he's going yellow. Appelle ça rison. But anyway. Oh, God. Oh, God. Huh? Oh, God. So, this little interlude, Mr. Deputy Speaker, sir, has managed to show us what I said a few seconds ago was true. In other words, it's just a semblance of us trying to have a debate on intelligent matters, and the other side, government, as I said, desperate in order to stay in power, desperate in order to be able to hold on to whatever is there, desperate. And this shows what? The last days in power of a government. And then the Prime Minister will have a lot of people he would like to blame around him because they sunk him. And one of them is Honorable Sinatambu. Anyway. So, as I was saying, I think it's important that the Honorable Attorney General explains those issues that we have questions. I'm not saying that he's bound to, but I'm saying as that in the name of democracy, I think it is important that he at least gives explanation to those questions. Answers have to be forthcoming. He has to clarify. And if ever there is an issue in law, it would be in the interest of our country that he refrains from proceeding with any amendment today and consult with his law officers, because it would be embarrassing for government if this is turned later on by the Supreme Court as being a violation of the Constitution. It would be very embarrassing. But then again, it's not in the name of ego, or one's ego, that we are supposed not to reflect on this particular matter. We have to reflect. As I said, you know, I mean, we're not here inventing the wheel. Otherwise, the United Kingdom would have had two bodies. France would have had two bodies, but Mauritius were just going for multiple mistakes. But then again, I think we should avoid that. Now, what also is very symptomatic of this government, fin de règne, I call it. Fin de règne. Someone just woke up. And it is what? I mean, very simple again. Look at section 17 of the Institute for Judicial and Legal Studies Act. When you look at section 17 that they are trying to amend, if you allow me, I'm trying to find that piece of legislation. Yes, and what I don't understand here is the following. I mean, that particular bill that we're bringing, the Attorney General is bringing forward, talks about clause 6, and at section 17, which is clause 6C, changing the Institute and Judicial and Legal Studies Act, amending it at section 17 by deleting the words Chief Justice and replacing them by the word Attorney General. In other words, it's important here for us to understand why is the Chief Justice being removed from the equation. What exactly is he being removed from? And I see here that basically what the Honorable Attorney General has done is simply gone as far as to state in the new act, when it will be commenced, this is what it will read like. It will show that now any regulations that are passed will have to be approved by the Attorney General and not the Chief Justice. So my question was, why is it that matters pertaining to sentencing guidelines and award of civil damages, why must it be done by regulations which have to be approved not by the Chief Justice? And the reason why the Chief Justice was the one who had to approve it is simply because it showed there was an independence in the matter. It concerns a matter of the judiciary, within the province of the judiciary, and an elected member of parliament forms part of the executive, cannot now trespass upon the province of the judiciary. We must have respect for the Chief Justice and the judiciary when it comes to this particular part of this particular legislation. So the question I ask myself is, why is it the Chief Justice will no longer be the one who is going to approve any regulation, but it has obligatorily now to pass to the Attorney General? What is the legal reasoning? Was there a request on the part of the judiciary for that? And if that is the case, the least that the Honorable Attorney General can do is table a letter to show the members of this House on both sides that this was a request from the judiciary. The person who is in reference here is the Chief Justice, whom we have a lot and we should have a lot of respect for. The whole judiciary, we should bow to the judiciary and show respect to the judiciary, because this is a branch of our democracy without which everything else falls. C'est le dernier rempart that protects our country against domination by those who live in ivory towers. The silence shows they understand, they know whom they mean. And now, then again, dogs bark. So what I'm saying here is very simple. The Attorney General should also be able to show us, if the Chief Justice himself has asked, that he no longer will be the one who should approve those regulations pertaining to sentencing guidelines and award of civil damages. Table the letter. But the Honorable Attorney General cannot table this letter. He cannot even tell us when he met the Chief Justice in order to be able to get his consent. And if ever there was a request, give us the date when you met with the Chief Justice in order to consult him on this particular matter. How long did the consultation last for? What did you discuss at that level of the consultation? What were his views? How did he express those views? And if he gave you his assent, his consent, and his approval, at least tell us when he did it, in what shape he did it, and be ready to resign if the Chief Justice comes and says it's otherwise. Because my information is there is no written document that would show the Chief Justice approving, because he did not approve. It's easy to come to this assembly and say, the Chief Justice approved, the Chief Justice approved, I consulted, I did that, oh, my law professor, whom I admire, blessed me. Good for you. That in no way takes the profession forward, does it? Your guru may be your guru, it doesn't mean it's our guru. My guru is the Constitution of this country. And this should be the guru of all of us as members of this assembly. However much we may have respect, and I have a lot of respect for all members of the profession, including the Attorney General, whom I may not agree with, but I respect him. But this does not mean we can do anything and everything in any way we want, but not adhere to the very simple principles that they said they would adhere to. The freedom to know, the freedom of information that this government is hiding and running away from. They are not coming up with the legislation. And him, if he believes at least in the principle of freedom of information, let him tell us, when did he meet the Chief Justice? How many times he met that Chief Justice? How many times he discussed it with the Chief Justice? And when did the Chief Justice tell him? And in what way did he tell him? And if it was not in writing, why was it not in writing? Tell us. Before I go to transit into the ICTA legislation, maybe then we will have to talk about the fake news element.
Address the chair, Honorable Mohamed, please.
Yes, I'm addressing the chair. I'm just looking elsewhere, but addressing you.
Addressing Honorable Boulay.
No. I'm just looking at him. He's a nice man. So, as I'm saying, then we go to another element that shows in the bill, this government, it's amazing. They want control on everything. They now, oh my God, I remember the times that they really beat us to the ground. You remember, Mr. Deputy Speaker, sir, when we were in alliance with the Labour Party and the MMM, how them in government, they made our lives hell, you remember? I mean, you do, I think so.
If you remember, I remember.
So we all remember. So since we are all on the same page, I think it's important. Because then again, I mean, that's reality. You can't change the fact, that's truth. And are you saying this to the Deputy Speaker or me? I'm on this side, same side. Now, my point is very simple. They made our lives so hard through the use, as Honorable Juval had put it, of the social media. And they were so good at it that we ended up, all of us, you'll recall, at one point at least, on the same side of the House, which was the opposition. Then, today, I remember a lot of things. I remember Honorable Bobby Ariram. I remember the declaration I gave against him, the declaration I made at the police station, Central CID. Those were the old days, 2015, because in politics, one day is a long time. And today is a good friend. Once upon a time, we never even spoke to one another. And today, Mr. Deputy Speaker, sir, in spite of what he had said, which was wrong against me, for which I gave a declaration, which is a breach of ICTA, let bygones be bygones.
Yes, we are all good friends, Honorable.
We are all. We are all. No. We get along with... We will try to reconcile them on the other side. We will try. but no, I know it's not you, I know it's Jagu. But what I'm trying to get at here is the following. I do not want to see, if we pass this law, whatever he had said against me on a Facebook page and shared, he would be behind bars for 10 years. I may be a political opponent of Honorable Oriram. Some people may want to see him behind bars for 20, but I would not want to see him not even for a millisecond behind bars. Thank you. Because this was a matter of his opinion. I may not agree with it. But to see anyone behind bars because of his opinion, can you imagine if he was behind bars, how would he have spoken to me and carried out his his duties as chief whip so efficiently? By speaking to everyone on both sides of the house. Can you imagine? From behind bars? Even his telephone calls he wouldn't be able to make. Can you imagine? So what I'm trying to get at here, at one point or the other, all of us have been victims of those allegations, insults, falling within the definition as provided for in the law and in the bill provided for by the Honorable Attorney General for the Information and Communication Technologies Act of 2001. And can you imagine? As I said, the offenses, Section 46, using telecommunication equipment to send, deliver, show a message which is obscene. Most probably Honorable Tarula knew I would come to him. But honestly, it wasn't even planned. I wouldn't even talk to him. He could come back. Indecent, abusive, threatening. How many times have we seen and heard all those definitions within an act done by members, maybe on both sides of the House? But then again, the problem, Mr. Deputy Speaker said, it does not concern only us. Why do I say this is a government of censorship? Oh, a lot of us would been to the United Kingdom. We've been to Hyde Park Corner. And the good days when we would walk in Hyde Park Corner and see anyone could just take a box, stand up there and make a speech. Honorable Ratna likes telling me that he has been to Hyde Park Corner. Honorable Ratna tells me that he's spoken his mind there. I wish he could have been in those good old days to have met him, where he could speak his mind and was not dictated by anyone else. But what I'm trying to get at here is the freedom of expression. The freedom of expression under Section 12 of our Constitution. The freedom to speak one's mind. But here, unfortunately, can you imagine? It doesn't only concern us. You know, every often when we lead a bill, we say, okay, maybe we want to attack another member of the opposition or another colleague politician. Forget about us. Let's talk about the youngsters of this country. Let's talk about the people of this country who use social media. Let's talk about all those who share amongst themselves photographs. For instance, I know, and I think the best thing is not to take anyone as an example. Let's take myself. You know, I myself have come across beautiful, I call it beautiful, but then again, I mean, cartoons of myself. And I laughed when I saw the one about myself trying to pull the leader of the Labour Party off his chair as leader. I remember that with another one with a cartoon of Dr. Boulel smiling behind me and saying, go on, go on. I enjoyed that. I enjoyed that. Can you imagine? Can you imagine how I laughed about it? But then again, this is a cartoon that is likely to cause annoyance. How many times have I not seen a cartoon of the Honorable Prime Minister where, God knows for what reason, they call him Pinocchio? I've seen cartoons about him with a long nose. Now, we may laugh about it, but obviously we must know what he feels like when he sees it, or when members of his family feels it. Maybe they will feel annoyed, and I would totally understand why they would feel annoyed. It depends in what shoes you're standing in. You see, I remember myself. I remember, you know, Honorable Oriram would remember those days. I mean, unfortunately, now he should be happy to know that Kathleen Austin has run away and she could not even defend herself, and basically I'm winning my case. But the thing is, I've seen cartoons of myself holding two guns as if I was an arms trafficker. And I had my son coming home and telling me, Papa, can I have one of those guns? And he's only 5 years old. But then again, I do not feel happy about it because my son doesn't understand the implications. I could feel annoyed about it. And on top of it, it's false. But does it mean that this person who on his side, he feels it's funny or he feels it's a joke, does it mean that he has to be arrested, provisionally charged, sent behind bars for such a heavy sentence of, what, 10 years imprisonment? Quel est le message qu'on essaye de passer à la jeunesse de ce pays, que à partir du moment où cette loi proposée par ce gouvernement, avec comme Premier ministre Pravin Jagnat, l'honorable Attorney General, vient de l'avant avec une législation qui qui va faire en sorte que, à partir du moment que ça a force de loi, les jeunes de ce pays ne pourront plus se partager les images. Même pas concernant les politiciens, même concernant eux, les amis entre eux, ou sur une connaissance, pour rigoler, pour donner pour une expression de leur opinion, pour se servir de leur instinct artistique, de créer une image ou un slogan. Ils ne pourront plus le faire parce que le gouvernement leur menace avec cette législation pour leur dire que vous, ceux qui vous servez de WhatsApp, vous vous servez de Twitter, vous vous servez de Facebook, vous vous servez de any social media for that matter. If you do that from tomorrow, this would mean that you could find yourself arrested, dragged to the Central CID, and handcuffed, provisionally charged, and found behind bars, bailed out, and finally sentenced to 10 years because your expression, your opinion, your freedom annoyed certain people. Your liberty that is enshrined in our Constitution under Section 12 caused humiliation. Then others would say, but no, it has to be that it is indecent or abusive or threatening. But Honorable Jagru feels threatened by any comment of him having been to Agalega and getting children to throw flowers at his feet. It doesn't mean that he was acting like a master. It doesn't mean that he held a whip in his hand. But then again, he feels that this is what they're saying, and he feels it's not true, and he feels that it is abusive, it is false, it is misleading, and he did not act like he was a master and that they were the slaves. This is not what his intention were, but he feels that what they're saying about him in all the attacks on the social media is wrong, and hence annoys him. Therefore, the people could be arrested for that. Can you imagine, Mr. Deputy Speaker, sir, how dangerous and far-reaching this is? Must I not talk about the case of Warren, the Crown versus Warren 2017, where in that particular case in the United Kingdom, which went on appeal, he was imprisoned, but it was important to talk about the Jake. It was in fact a joke. It was not the case of Warren, but it was another case. It was a court in July 2012. It was a High Court judges. The trial is commonly known as the Twitter joke trial. And with regard to that case, it was the court quashed a 2010 conviction of a 27-year-old man and the £1,000 fine for a tweet in which he jokingly threatened to blow up a local airport because of his frustration that it was closed because of bad weather. The judges said it was his joke. Because it was bad weather, he just jokingly said, I'll blow up the airport. In the judgment, the judges said, quoting Shakespeare, he said, and Honorable Ratna likes quoting Shakespeare, maybe I could refer this one to him for future reference. It's a good one. They are free to speak not what they ought to say, but what they feel. In other words, when you feel something, we're free to say it, we are free to express it, and when we feel that someone depicts something, this is our feeling, we cannot now come and curtail their freedom of expression. We are here jeopardizing the freedom of expression of a country, of a generations to come, of the future of this country. The creativity of people is being endangered. Is the law sufficiently armed in order to take action for defamation against those who have defamed? Yes, I have taken action for defamation against those who have defamed me online, on the social media, with the telephone. Every day it happens. It happens at the Central CID. It happens before our civil jurisdictions. But why, therefore, do we have to come with something more? There is only one thing. And Honorable Gayan says there is nothing sinister. Can you imagine the time when there was a budget speech in this August Assembly, and Honorable Gayan was getting, his whole speech was about one political nominee that he had named, that was eventually fired by another minister who came after him? Can you imagine how angry he was that part of his speech was only that, where he is attacking the media just because of that political nominee? Do you know how annoyed he was? Now, he would say all allegations against that political nominee, what he would say? It's false. He would say it's misleading. He would say it's indecent. He would say it's abusive. He would say that they're attacking her so much, it's threatening. And he's annoyed, or she's annoyed. Can you imagine? Just because Honorable Asnu took another direction that he did, he could feel annoyed. He could feel threatened by his colleague. And he could even report his colleague. And his colleague could find himself behind bars. Thank God he did not share anything using a telecommunication device about decisions that he took, or about his views about what the leadership of his party took. Thank God he did not. So, you will recall, Mr. Deputy Speaker, sir, when Honorable Gayan spoke, I kept quiet and listened. But then again, we learn at all ages. So what I wanted to get at here is, why is it therefore that government is being so difficult with regards to la liberté d'expression? Now, if our legislation did not contain laws and paragraphs in our laws that was enough to take criminal action, to institute legal proceedings of civil nature, then I would say, okay, we have to parfaire la loi, because the law does not allow us to take action, we can even go for injunctions for someone to remove something he has posted on the net. We can even go before judge in chambers, because this is causing immense prejudice to my reputation. Remove it, because it is a violation of existing law. This we can do. We can even obtain redress, damages, compensation. We can do that according to our laws. People can be criminally prosecuted for what Honorable Gayan fears. And he is right to fear. He is right to condemn. But why, therefore, do we have to try to kill a mosquito with a nuclear bomb? Why do we try to have a solution qui est démesurée? Démesurée complètement. Here, because the only objective of this government is to ensure 1 year at least before election that no one criticizes them. Can you imagine how many documents I have against ministers on the other side? Can you imagine how many documents and checks, payments, everything I have against certain people? But then again, I decide when I want to bring it out.
Yes. If the honourable member is making such allegations and he has the documents in his hand, he should put them on the table. He cannot go on making allegations which are baseless like this. Yes. If you have the courage, if you have the guts, you put them on the table.
I'll go on, because then again, he doesn't decide my agenda. Yeah, you should be sorry. You should be sorry. Why? I won't sit down. I won't sit down. I won't sit down. I won't sit down. He's just been drinking away. Maybe he should go
Honourable members, may I request you to take your seats? Honourable Mohamed. Please, honourable members. Honourable Mohamed, you are reaching the end of your speech. Let us do it in a very democratic way. Please.
As I've said, you know how it hurts? You see, Mr. Deputy Speaker, sir, how it annoys and how it hurts? But I decide when I will make it public. I decide how. I decide how. But then again, they can say whatever they want, but the day it comes out, he's going to cry. I'm waiting for them to go on. But then again, I mean, dogs may bark, let me go on.
Please resume your speech, Honourable Mohamed. Please.
So,
Can we have some silence?
When you look at the Article 19 of the Universal Declaration of Human Rights, everyone has the right to freedom of opinion and expression. The right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. This is exactly the Universal Declaration of Human Rights, Article 19, that this government is coming to try to destroy, undoubtedly, by using words of trying to show their manhood like Capon and Capon. That's all they're good for. But the truth is what? The truth is what? But if the hat fits, wear it. And then when you look at annoyance, my friend Honorable Juval referred to the definition in the Oxford Dictionary. I looked at the Collins English Dictionary. The feeling of being annoyed, just like Honorable Gayan just now. The act of annoying, just like I'm doing to him. A person or thing that annoys, just me annoying him. And annoy, to irritate, to displease, just like I'm irritating him and displeasing him. To harass with repeated attacks, just like he's doing to me. Now, in democratic societies, Mr. Deputy Speaker, sir, media has always been considered as the fourth state. Media is, in my humble view, Mr. Deputy Speaker, sir, the essence and backbone of democracy. And whenever I hear Honorable Gayan speak, and he's lashing out against the press, lashing out against all social media, everyone, he is the one who can give lessons to everyone. I mean, we have to just keep quiet and listen to him and say, yes, sir. Yes, yes, yes. I mean, obviously, he is a great man. I have to learn from him. I admit, I don't know much. But I have to learn. I admit that. He is my senior, and I'll always learn from him. But not on all issues. On all issues, maybe he should learn from his senior. It reminds me of a Trump tweet. And maybe he's learning from President Trump. And it's at 5:09 p.m. on the 11th of October 2017. And this is what Trump tweets. Network news has become so partisan, distorted, and fake that licenses must be challenged and, if possible, revoked. Not fair to the public. I mean, in other words, this is exactly what Honorable Gayan is saying. That there's fake news, that people are unfair, that they are being so partisan, distorted, and they should be reprimanded, and we should amend the law, and we should control Facebook. But at no time did he say it in their manifesto. You will recall when we read their manifesto and when we criticized their manifesto in 2014, Mr. Deputy Speaker, sir. At no time did they say that they would come and curtail la liberté d'expression. At no time did they say that what Honorable Gayan said. Honorable Attorney General did not say it. He tried to be very factual, but the truth comes out because it was annoying him. It was gnawing at him. And he had to come out. And what it was, we have to control Facebook. We have to control social media. This is his whole object. They want to be able to be a government of censorship. But what they're going to do is try to say that this legislation is not to control. They have to try to give this impression of doing something good, what it is. They're going to try to stop child pornography. Is this the legislation to do it? They're going to try to stop harassment of children on the internet. Is this the legislation to do it? Yes. No, this is not the legislation to do it. This is not the proper method of doing it. This is not the main legislation pertaining to those problems of society that need to be addressed, not in a haphazard manner, in a piecemeal manner like this government is. They are hiding behind children victims in order to give themselves a new virginity. This is what they're doing. Because in fact, they are spent, they are gone and will never come back. So what they do is that they try to put as a paravent the poor children who are trying to help, the poor victims who are trying to help, the poor victims of society who are trying to help. But we will not amend the real legislation. We will just pretend to amend. Because here, what they are trying to do is protect their own interests. Because this is all they are concerned about. That's all. This is all in his mind, a ticket. This is his be-all and end-all of his living. My God, that is why his knees are hurting so much. That's why your knees are hurting so much. Huh? Oh, you my God. Now, I mean, as I said, the last issue is the issue of giving the chance to the courts to amend a sentence that has been entered wrongly in law. That is with regards to error in sentence, clause 4. I have, and here it mentions 7 days after sentence. I think it is an interesting piece of amendment. On that particular note, I agree with the Honorable Attorney General that something had to be done. My only humble advice would be, if we look at the situation in the United Kingdom, it's called the 56-day slip rule. This 56-day slip rule did not exist at the time when we were reading law there. And basically, what is a slip rule? It is where the Crown Court, by virtue of Section 155 of the Powers of Criminal Court Sentencing Act of 2000, has the power to alter a sentence and other order made by the Crown within 56 days from which it was made, where there has been a factual or legal error, or in cases where further evidence and information has come to light that is relevant to the sentence or order made. Also, maybe where a court has overlooked statutory provisions limiting its powers. So maybe this is the only similar legislation that exists in the United Kingdom. But then and that is the case of R versus Warren of 2017, which I had mistakenly referred to earlier on, Mr. Deputy Speaker, sir. And here it was basically where the appeal court said that the courts have a discretion to act and can only use the rule in certain circumstances, but in not all circumstances. You have to act rapidly. But then again, maybe my humble suggestion here would be maybe 7 days is not sufficient. I'm of the view that normally after sentencing there are 21 days to appeal, and I think that at least within the 21 days, maybe 2 weeks, or even the 21 days as a maximum, could be a humble suggestion I'd like to make, because very often with the mechanism of the judiciary and the time that it would take maybe the DPP's office to alert the views of the learned magistrate, maybe 7 days would not be sufficient, and an important issue such as this one have been missed, and in the interest of justice on both sides, I think it is important that some more days be given. 7 days is very, very short indeed, and I humbly suggest that it at least is increased to 21 days, which is the time that it takes to appeal. So, in conclusion, let me just say that there is some good in this bill. I've just referred to it in the last instance. It is a pity that we're going for piecemeal amendments. I'm here expressing the views of also me, a member of the Mauritius Bar Association. The Mauritius Bar Association was never consulted as far as the amendments to the laws. The Mauritius Bar Association was never approved this, and it is a pity that the Attorney General did not even consult with them. I'm not saying that he should have consulted with me or any other barrister, but at least with the council, and they would have expressed their views and shared it with him. Now, I understand, as I've said, and I conclude on that I've got a lot of good friends on both sides, meaning private practice as well as law officers who do a very difficult job, who are excellent at what they do, who are properly trained, and who are an honor. It is an honor to know them, because they make the wheels of justice turn, and without them it would not turn in the right direction. I totally understand that maybe they have not been dealt a proper card when it comes to the manner in which the Mauritius Bar Council may have dealt with any complaints pertaining to them or reports. And it should have been done differently. I take that. But that's not reason enough to go as far as to create two categories of barristers. This would not be in the interest of justice, and in my humble view would be a violation of our Constitution, because the Judicial and Legal Service Commission does not have that power. Those are my observations, and if I've caused offense, I do apologize. That was never my intention. Thank you very much.